Recording.
Hello, everyone. My name is Thomas Tripodianos. I'm managing partner at Welby, Brady Greenblatt, and I'm here to speak to you on behalf of the New York State Builders Association with regards to the New York HERO Act. If you have any questions, my contact information is presented in all the slides. Feel free to reach out after this presentation. And I thank you for attending, and thank you for the Builders Association for the opportunity to present. So the New York HERO Act, which is really the New York Health and Essential Rights Act, was actually signed into law by former Governor Andrew Cuomo back in May of 2021. And it was went through pretty quietly because it didn't really require that much response on behalf of anyone until an emergency is actually declared. Obviously, it goes by the acronym HERO Act, and essentially requires the state's Department of Labor and Health Department to implement and enforce minimum workplace safety standards related to airborne infectious diseases. Obviously, this was done in response to the COVID pandemic, but the HERO Act is not limited to responding to the COVID pandemic. It carries through to any airborne infectious disease plan. So it doesn't apply to the flu, for example, though. So the seasonal type of diseases that we're all kind of accustomed to living with. There has to be a designation by the commissioner that is a highly contagious and communicable disease, which also presents a serious risk of harm to public health. The reason it should be on everyone's radar right now is that Governor Hochul on Labor Day did designate COVID-19 as qualifying as one of those diseases that would trigger obligations under the HERO Act. The HERO Act is codified in two sections in the labor law. Section 1, you'll see the citations right there on your screen. Section 1 requires that employers prepare model safety plans and that they are distributed to their employees. Section 2 requires specific employers to establish workplace safety committees with their employees. And we'll go into further detail a little bit on what that means. A couple of definitions of who's covered. Employer is it's a pretty expansive definition. It includes almost any type of entity that you would operate under, and any type of employing or hiring that you would do as that entity. So basically, if you pay anybody to do anything, you're most likely covered under the HERO Act. Like many New York State legislative actions, they exempt the government itself from compliance. Employees, I guess it's the mirror of the definition of employer. It's basically, if you do anything and get paid for it, you would be deemed an employee. The actual definition is on your screen. And again, state and government employee agencies are exempt from the act. Worksite, similarly very expansive. It's any physical space or vehicle where you are performing work or where you are going to and coming from work, except if you're going to work from your house or your residence and returning to your residence, that trip would not be considered a work site. So what do you need to do? So first, the obligation was on the state DOL and Department of Health to create and publish standards as well as model plans for all work sites and designate them by industry to establish the minimum requirements to comply with the HERO Act. There are a number of things that the statute prescribes these departments to do and protocols to be developed. And they include, number one, And you'll see that a lot of these are very, very similar and familiar to things that most of us should have been doing in response to COVID already under the various governmental mandates that we've seen come through, CDC recommendations, health department recommendations, et cetera. So number one is employee health screenings, two, face coverings, PPE is required, and that is something to be provided to employees at the employer's expense. Hand hygiene, cleaning and disinfecting of shared work equipment and surfaces, for example, hand tools. Social distancing protocols, mandatory or precautionary isolation quarantine orders, engineering controls, which is basically controlling access to sites or mechanical ventilation. That would be an engineering control. Assignment and enforcement responsibility of the safety plan. And this was something that was required under the reopening plans in New York. Compliance with employee notice requirements, which as I alluded to earlier, is the distribution of the plan, and a verbal review of the standards and policies and employee rights. As an employer, you have the option of adopting the labor commissioner's plan or creating your own that meets the standards that are published by the commissioner. I've yet to see anybody who really truly needs to develop their own plan and not use the model DOL plan. I suppose they would exist, but considering that the DOL has developed them by industry, I haven't seen anybody who had the need to go off and develop their own plans. If a union employer chooses to establish its own standards, it has to do so in consultation with the collective bargaining representative, or if you're in an open shop environment and you want to adopt your own plan, it does require employee participation to do so. So again, like I said, it passed pretty quietly in May because there was nothing really to be done by employers. But in July, the Department of Labor with the Department of Health did release their prevention standards and their model plans, which triggered obligations then on the part of the employers, which have now passed. So if you haven't done this, you're already a little bit behind the eight ball, but 30 days thereafter, which would have been August 5th, you would have to adopt a plan for your own business. The standards here are the links for the standard as well as the various model plans. You can get these when you get the slide. You could probably find them if you just do a Google search as well. And there is one for the construction industry specific. That was the first link on the prior page. So what do you need to do once you adopt a plan? That means you have to distribute it. You have to distribute it both in English and in the primary language, if other than English upon hire. So the DOL sites, you'll see they do have it in English and Spanish as well as other languages. And if you happen to have a closed business because of an infectious disease, then you would have to again distribute it again after that, after the reopening. You have to post it on the work site and incorporate it into your employee handbook if you have a handbook. The posting at the work site is similar to all the other labor law posters that you should already have. So it could be done in the trailer, it could be done in the cafeteria room, wherever you post right now, you should post this plan along with it. You also have to make the plan available for review to any employee, independent contractor, employee representative, union representative, the labor commissioner, and the commissioner of health. So you need to have a copy on hand for any one of those individuals who request it. You have to communicate the plan within 30 days after that. So that would have brought us to Saturday, September 4th, which was pushed forward, I guess, to the Monday after. So communicate again means the distribution and the posting, which I just discussed, as well as the incorporation into the handbook. So if you haven't done any of these things already, you kind of need to get on track. It does provide for anti-discrimination in the statute, so you can't discriminate, threaten, or retaliate otherwise, or take any other adverse action against any employees who exercise their rights under the Act, who report violations of the Act, or seek assistance for a concern they have with respect to an airborne exposure. You also refusing to work when the employee, if the employee refuses to work because they acted in good faith, they believe that there is a dangerous exposure due to working conditions that are inconsistent with the HERO Act. So if an employee doesn't want to come to work and they have a good faith reason for not coming to work related to an infectious disease, you can't discriminate against them. What are the penalties for not following the statutes? They are $50 a day for failure to adopt a plan, and no less than $1,000, and not more than $10,000 for failing to follow a plan. There is a private right of action in certain cases for the employee to seek injunctive relief, which is basically a court order either directing someone to do something or to stop doing something. And if the employee does bring such an action, there is the ability to award costs, attorney's fees, and liquidated damages of up to $20,000, which is double the $10,000 penalty. If the employee decides to bring their own action for injunctive release, the standard that they have to meet is that the violation creates a substantial probability that death or serious physical harm could result from the condition that is being complained of. There is a defense to such an action, which basically says if the employer did not and could not, with reasonable diligence, know of the presence of the violation. As mentioned before, the court may award costs and attorney's fees in any such litigation. However, before bringing such an action, the employee must put the employer on notice of the alleged violation, and the employer has an opportunity to cure. So there's a 30-day waiting period after the notice is given to allow the employer an opportunity to cure. If they continue to disregard the notice, then obviously litigation may move forward. There's also the concept of a futility in providing this, but the employee has to make specific allegations with particular facts that the employer is persistent in being unwilling to implement a proper protections against the airborne disease. There is a 6-month statute of limitations from the date that the employee had knowledge of the violation for the employee to start such an action. If the employee brings a frivolous claim under the statute, then the employer can be awarded costs and attorney's fees either against the employee or against the attorney for the employee, or both. I've gotten a lot of questions about what is the Joint Labor Management Workplace Safety Committee. That's what you'll see in Section 2 of the Act. So before that Act applies, the employer has to employ at least 10 employees or have an annual payroll of $800,000 and a workers' comp mod of more than 1.2. That's for Section 2 to apply. What does the employer have to do? Essentially nothing. And that's really what that section of the statute prescribes. It says a covered employer must permit employees to establish and administer a joint labor management workplace safety committee. So all it says is you can't stand in the, as the employer, you can't stand in the way of the formation of these committees. There's only one committee required per work site. And remember, the definition of work site is any location where work is performed. So a single employer can have multiple work sites, but there's only one committee required to a work site. So think of it as if you're in construction, you have a home office with back office personnel working there. That's one work site. Each one of your construction sites is an additional work site. So if a committee is to be formed, it has to be 2/3 non-supervisory employees who are chosen by non-supervisory employees, unless you're a union employer, in which case the collective bargaining agent will choose. If there are multiple geographically distinct work sites, so think of it as different locations on a job site that are geographically distinguishable, then you can have multiple committees at that job site. As the employer, you cannot interfere with the selection of employees who serve in this committee. And you cannot retaliate against any employees involved in the formation or participation of the safety committees. What can the committee do? They can raise issues to the employer with regards to health and safety. They can review occupational safety and health policies. They can review policies enacted in the workplace in response to things such as laws and executive orders that are issued. They can participate in governmental workplace site visits unless prohibited by law, which really harkens to a criminal type of investigation. But if it's a Department of Health visit or a Department of Labor visit, they have the right to be present at those. They can review any reports that you file as an employer pertaining to workplace safety and health. They can hold meetings during the workday, no longer than 2 hours, and those meetings would be limited to quarterly meetings, so 4 times a year. They can also allow committee designees to attend trainings, for which they would still receive their regular rate of pay for a maximum of 4 hours on the function of workplace safety committees and an introduction to occupational health and safety. So there are 5 takeaways from this presentation. If you didn't pay attention to the first part of this, pay attention now, because here are the highlights. So 1, all private employers with work sites in the state are required to implement the safety plan under the HERO Act to prevent against employee exposure to airborne diseases such as COVID. You can adopt the template plan that is provided by the DOL or establish your own, as long as you're meeting the DOL standards for such a plan. You should have already done this. 2, the exposure prevention plans have to account for what is required in the statutes, which are listed here on the sheet, and which I went on the slide rather, and which I went through earlier in the presentation. 3, employees who are covered by the plans are basically, it's a very expansive definition. That's basically anybody who gets paid to do anything. Employees or independent contractors of the state are of course exempt. Employers are barred from discrimination and retaliation against any employees who either report violations under the HERO Act or refuse to work because they believe in good faith that if they did show up to work, it would be an unreasonable risk of exposure. And 5, if you did not adopt a prevention plan, You're subject to fines of at least $50 per day until you do implement one. And if you fail to follow the plan, the fines are between $1,000 and $10,000, with potential damages going higher if an employee decides to sue under the HERO Act. So that concludes the presentation. It's a very simple, straightforward act. Nothing too complicated there, especially because the forms are provided by the Department of Labor. They're very easy to fill out. It shouldn't take you more than 15 minutes to half an hour to complete the form for your particular industry. Again, if you have an office setting as well as a construction site setting, you may need to adapt 2 different plans to account for the different settings, both of which, in that example, there would be forms provided for on the DOL site. And remember, they have to be the multilingual, which also are provided in the DOL site. So if you have any questions about the HERO Act or your obligations thereunder, please feel free to give me a call. My contact information is available on this slide. Thank you, everyone, and have a great day. Stay safe.